Hello all, this is Raymond here. I wish to address the recent newspaper report on court ordering Iris Koh to make payment to the lawyer. I am speaking as Iris' husband and not for healing the divide. As this is the first time I experienced Iris being arrested and away so long on a 15 days remand, I was devastated. Do note that I have not been separated from her ever since I know her about 15 years ago. I am not here to comment on what the judge has decided, as this is the judge's prerogative and not mine. However, the lawsuit between our lawyers and ourselves, while regrettable, was necessary. In our view, the legal fees were too much. Since Iris' fees were crowdfunded, we had a natural duty to protect the use of such funds. Fortunately, the court agreed with us and reduced the fees from a big fee of 30 over thousands to merely 17,000 plus. It was a near to 50% reduction of fees. Did the press say anything about a huge fee reduced by near to 50%? Of course not. The press just want to focus on the bad things by not focusing our main point about the lawsuit, which is to reduce the fees. We feel that we must pay our lawyers their fees, but not when it is overpriced. All the more when the fees are crowdfunded, we need to be extra careful when spending the money. Fortunately, the court agreed with us and again reduced the fee from 30,000 to 17,000. We knew that the press would take the chance to have a smear campaign on us again. As expected, they just reported the negative part and did not even get the amount correct. They did not report that the lawyer's invoice has been reduced by near to 50%. We want to be responsible to our supporters, and that is why, even though we know that the press will attack us, we still have to tell our lawyers that their fees are unreasonable and too much. And to address what the judge says about our conduct, is it true that I was rude to the lawyer? The answer was an unfortunate yes. I apologize to Mr. Clarence Roon for my tone, but I do not apologize for my content and my objection to his execution, or rather non-execution of my instruction. It is the first time my wife has been arrested without any access to her family and lawyers. In Singapore, during the investigation stage, no next of kin can ever visit a person in remand unless the next of kin is dying, so the police may grant it on compassionate grounds. The only thing we can do is to see her, to read her rights as a defendant in a criminal proceeding. As a lawyer, he should not have asked for a spousal visit, not to mention that he has been instructed specifically to ask for a lawyer visit to read her rights as defendant in a criminal proceeding. To be fair, I also asked the lawyer to let me read her rights. But of course, I think the law would prefer a lawyer to read her rights than a husband to read her rights. I also told the police officer I'm willing to give up spousal privilege, okay? Since spousal privilege can be in private and the law cannot interfere. But I told them I'm willing to give up my spousal privilege. An instruction he ignored, and he asked for the spouse to visit in place for full spousal privilege. Okay? Our lawyer, Mr. Loon, during Miss Iris Koh was in remand, has not met her a single time to read her rights as defendant. The pamphlet of rights has never been passed to her. Do note that the pamphlet of rights is the paperwork to pass to her when anyone is being arrested. Right? When I reminded him to go to see her as a lawyer, he said that Iris knew her rights. I won't know whether she knew her rights or not, as this was her first time being arrested. This advice, in fact, to ask for limited access for rights to be read to her. This advice has been, in fact, given by another set of lawyers. I repeatedly reminded him to just ask for limited access to read her rights. At that point of time, I do not want to hurt his feelings. I just told him that this advice, I want it to be done, without telling him that actually this advice was given by another set of lawyers, by full-time criminal lawyers. Okay. He, however, disregarded my instructions and asked for a full spousal visit to visit her. I knew for a fact it won't be granted. And also, me meeting her in remand had no benefit to her at all. So I am not asking for that. I was not asking for that. If I were to be granted the right to read her rights, I would tell her to volunteer evidence that is advantageous to her defense, since she is innocent. In the end, I was able to read her written note. I was able to pass her a written note, which the investigation officer was willing to pass to her, reminding her that she could be forthcoming with evidence that is to her advantage. For the police officer, they are obliged to consider all evidence, whether it is in the advantage of the defendant or in the detriment of the defendant. But as far as our rights are concerned, right, we do not need to give any evidence in detriment of their defense. But in any case, there is no evidence in detriment to her defense because she is innocent. Okay. Naturally, I was very distraught that this basic instruction was not followed. I did threaten I may sue him, but I think the reduction of fees is sufficient for me. I hope it is sufficient for him as well. Later, we found out that there was an outstanding case. The Law Society is also taking action on the lawyer. I do not know enough to comment, nor do I know whether the proceeding has ended, so I better not say anything, as it is sub judice to comment on any ongoing case. I would not hazard a guess as to whether he is in the wrong, for again, it is up to the court or the Law Society to decide. However, upon hearing this news that the Law Society is taking disciplinary action of the lawyer, would I have confidence in the lawyer? Of course, the answer is no. We do not have confidence in him. And given our rather short interaction, we are not able to work well as well. So we say bye-bye to one another. I wish him all the best. While I should not have spoken to him with such a tone, I do not regret the content at all. Best regards. Thank you very much.